Very happy to be with you today. And one thing I would observe at the outset is, unlike Wakanda Forever, we will only last 1 hour today. And so we will have a hard stop at 1 o'clock. We do invite your questions throughout this. If you have questions, please use the Q&A function. I always like to start with this quote. I think it's a great quote to highlight some of the importance of the decisions we make around topics of legal ethics. And one thing that's worth noting at the beginning is you do not have to make these choices in brief seconds. The model rules of professional conduct always allow you to seek opinions, which we, among others, many others, provide. And so please exercise your opportunity to get guidance if you have any ethics issues along the way. I do want to start with a brief invitation for you to join my column, Dear Ethics Lawyer. It comes out on the 1st and 15th of every month. And it is a very simple, you will see questions here today, simple 1-paragraph questions followed by 1 or 2 paragraphs of answers. That is the format for Dear Ethics Lawyer column. It goes out to 6,500 lawyers around the country currently. If you'd like to be on that list, it's free. It doesn't get you a bunch of spam emails. It just comes in your inbox and you can delete it, read it, or whatever, but I think you'll find it useful and pretty interesting. Paul?
Hello, everyone. Good afternoon. The pattern that we're going to do in this particular CLE is it's going to be a question and answer CLE, very similar to Mark's column, which is an easy read and provides a lot of information, especially for in-house counsel. I'll be asking the questions sort of as the role of in-house counsel. Mark will be answering them, and we'll have some back and forth. I will tell you, us Texans tend to think that Texas is a whole different country, and the ethical rules are a pretty good example of this. Although we're going to be focused on the model rules, Texas has adopted some of them and has not adopted some of them. In Texas, the disciplinary rules are very much guidelines. Courts can cite them as persuasive authority, and sometimes they're more persuasive than others, but they don't give rise to a private cause of action, nor do they create any presumption of a legal duty being breached. So if you want to know what you're actually allowed to do in Texas in particular, but really any state, you've got to dig into the case law. All right, you ready, Mark?
Ready, let's go.
Okay, so the first question involves a law firm pitching your company and then becoming adverse. So Mark, 6 months ago, my company interviewed a small team of lawyers from 3 different firms to represent the company in a substantial litigation matter. In the course of those interviews, we shared facts about how we operate and about our people that we regard as confidential in order to be able to pitch us the strategy they would propose if hired and estimate fees and costs. Now, one of the firms we did not choose in this process is counsel for an adverse party suing us in a different but similar case. It feels like they know too much from our prior interaction, although we did not hire them. Can we consider a motion to disqualify them?
Yeah, so this comes up now and then, and the model rules actually have and for purposes of today, we are talking about the model rules of professional conduct that the ABA has promulgated, and I will refer to the most current version of them. It is also important to remember that states, there have been 6 or 7 versions along the way over the last 30 years, and states have adopted different chronological editions of the model rules too. So some of these are important to pay attention to when you're digging into your individual state, wherever your problem arises. So this problem is addressed by Model Rule 1.18, which specifically addresses prospective clients, and it provides protection both for the law firm and for the company in this situation. The company, in the language of the rule, is a quote prospective client, and once the lawyer participates in the conversation about whether they should be hired, that lawyer then takes on the obligation to keep the information that the company provides confidential and not to use it for any other purpose. And the other protection by the rule that the rule provides is that equivalent to that provided in former clients under Rule 1.9. And so, for example, neither the lawyer nor the law firm, at least without a waiver, can proceed subject to some other things if a subsequent matter if they would be adverse in a subsequent matter that is the same or substantially related to the matter about which they talk to the client as a prospective client. So here, the way this hypo has been constructed, it sounds like this is a similar matter to the one that was discussed. And so we're going to assume that that is a substantially related matter. And so then where does that leave the client, the company, and the lawyer? Well, so the lawyer cannot proceed, period, at least without a waiver, in the new matter. However, if the lawyer and her law firm have taken the right steps under Rule 1.18, the law firm itself is not necessarily disqualified in its entirety. So there are three things here. The lawyer originally has to have taken reasonable measures to avoid exposure to more disqualifying information than was, quote, reasonably necessary. So practice point here, really for both sides of this discussion, is try to limit the information that the company gives the lawyers or the lawyers get from the company in order to just that's needed for the discussion. The second requirement that in order for the law firm not to be fully disqualified is that the lawyer who participated, lawyer or lawyers who participated in the discussion with their prospective client are then timely screened when the subsequent matter arises, so that they don't communicate, they can't communicate, they're screened away from the electronic records and the paper records, et cetera, from the second matter, and are not allowed to participate. So a timely screen is set up, and they're apportioned no part of the fee from the new matter. And then this is the killer that some firms will forget. The firm also has to give prompt notice to the prospective client that says, hey, we've set up a screen, we're now going to proceed in a subsequent matter adverse to you. So there's a lot of details here for the law firm to take, and if the law firm misses any of those, then yes, very much your client, you as a client, can consider a motion to disqualify them. And at least in a model rule state where the 1.18 is in existence, you've got a pretty good shot at being successful in that disqualification effort.
And of course, this is one of those that Texas is even more nuanced. Texas did not adopt model rule 1.18, although it did indicate in the preamble to the professional rules they adopted that some duties, such as confidentiality, may attach before a client-lawyer relationship has been established. And specifically in the comment to Rule 105, that confidentiality duty may attach even for people that sought to employ the lawyer. So Texas doesn't have this model rule, and a court might or might not look at these screening things as adequate protection in Texas, and the Texas duties on confidentiality with regard to a lawyer that has not been engaged are definitely not as clear. All right, let's move on to the second one, discovery of a completed fraud. Mark, I represent my company in selling an industrial property. After the conclusion of the transaction, while reviewing records for a different purpose, I discovered that one of my business representatives who had received a bonus relating to this event made a misrepresentation concerning a material condition of the property that was sold. What may I do and what should I do?
Okay, so this is not, unfortunately, is not a particularly uncommon situation. You have basically a rogue employee who, in order to boost his bonus in a particular period, has committed a fraudulent act in closing a transaction. And after it's all done, you didn't have anything to do with it, but after it's all done, you come across facts that suggest that to you. So what do? Well, as a threshold matter, you always may and you always should, under Rule 1.14 and in an organizational context, Rule 1.13, the rule dealing with representations of organizations, you should consult with the appropriate representatives of your company client under the umbrella of privilege. And that part of that discussion should be not only to inform them that you've discovered what appears to be a fraud, but to find out if there's any other explanation. Obviously, an investigation needs to be done that maybe this isn't a fraud, but you know, once you verify that, then discuss what the consequences are to your company of disclosing and or rectifying that or not. in most cases, consequences might be exacerbated if you don't take some action, but that is a subject matter that you absolutely need to discuss with your client, regardless of any other aspect of the ethical rules. The thing too that you may do along the way here, as I foreshadowed earlier on, is seek advice from outside counsel and or ethics counsel about what your obligations are in that particular jurisdiction where this fraud has occurred. The rules, and specifically in the model rule context, we're talking about Rule 1.6, the rule on confidentiality. The rules are a little bit across the board, in part based upon which version and time of Rule 1.16 the jurisdiction has in place. The early versions of Rule 1.16 did not allow any disclosure of facts that constituted a completed fraud, at least without client consent. Later versions have, including the version that is now in place, do permissively permit some disclosure of completed frauds. But let's start with Model Rule 4.1b. Model Rule 4.1b states the lawyer shall not knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6. So Rule 1.6 is the trump card here. 4.1b is the rule that really talks about frauds in progress, frauds or crimes in progress. And so it doesn't apply here, but it's sort of the starting point that spins you off to Rule 1.6. Rule 1.6 then, the current version, subsection A3, states that the lawyer may, it's permissive, reveal information to prevent, mitigate, or rectify substantial injury to the financial interests or property of another. And some of the earlier versions had this similar language, but it was limited to bodily injury or other physical harm. But the current version does allow you to permissively disclose information to mitigate, rectify financial frauds, basically, in furtherance of which the client has used your services as a lawyer. So if you weren't involved in it, then you have no duty whatsoever. But if your services were used, then this permissive disclosure opportunity arises. But it is permissive. It's not required, at least in the absence of other law in the jurisdiction that perhaps may suggest that if you're permitted to disclose it, then you should. And again, this is a cautionary note to make sure, if this arises in your experience, to make sure that you understand not only the ethics rules, but the other law in the jurisdiction concerning your obligations if there is a fraud. So in general, this is where it leaves you in the circumstance that first you should consult with your client and counsel them about whether they should authorize disclosure or undertake to mitigate it themselves. And then second, you're placed into the position, at least in the most current version of the rule, of being able to but not required to, which is a very awkward position. And I highly recommend in that circumstance that you get advice from outside counsel.
And two quick follow-ups. So Texas has adopted the most modern version of this rule, although they renumbered it to 1.05 in Texas. So two questions. First, if I go to my boss in the organization, tell him about the fraud, and he says, be quiet, have I fulfilled all my ethical responsibilities? And second, does it give me or the organization greater protection to get an outside opinion from counsel regarding these kinds of issues?
Yeah, so the answer, Paul, those are great questions, and unfortunately questions that arise too often in this context. The first question is, yes, probably you have discharged your obligations. The question is, though, whether continued non-disclosure of the fraud continues, it causes harm to the organization, to the company, is it likely to result in continuing harm? If that's the case under Rule 1.13, you have an obligation to run that up the corporate ladder, to the highest reasonable decision maker, to make sure that the company is counseled about the need or potential need to disclose that. At the end of the day, though, given that you are not required to disclose this, it is only permissive if your client tells you not to. You have probably discharged your obligation. Although, again, I don't think that trumps your permissive ability to disclose it if you really felt like for the benefit of your own reputation you needed to. It's probably not going to be too good for your job status, but that's where you end up.
All right, let's go on to the next question. Question 3, negotiation ethics. Mark, I'm a business lawyer negotiating with an opponent over the price to acquire a non-public company. May I state that the business is only worth $10 per share, although I have sitting in my desk an expert valuation opinion at $15 per share? May I also state that $12 per share is all I will offer if my client has in fact given me the authority to go up to $15 per share?
I love discussions of negotiation ethics, and I really wish this, for the purposes of this question at least, that we had a live CLE, because these are good questions to discuss as part of a group. But be that as it may, let's go on and talk about this a little bit. Model Rule 4.1 is a rule that we should all be familiar with, and it basically states the obvious. In the course of representing a client, a lawyer really shall not lie, shall not knowingly make a false statement of material fact or law to a third person. And so your first instinct is any deceptive conduct or anything where you say something that's just not true is a lie and would be violative of this rule. And I think that a lot of people are comfortable with that, but would be and perhaps would be uncomfortable within comment 2 to Rule 4.1. The rule talks about false statements of material fact or law. It does not talk about expressions of opinion. And comment 2 to Rule 4.1 picks up on that a bit. And it states that under generally accepted conventions in negotiation, certain types of statements are ordinarily not taken as statements of material fact. And the example it gives, in the case law pretty much limits this to the example it gives, really not much broader, if any. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category. So it's interesting, and there's been a lot of discussion over the years about why they put that in the comment rather than in the language of the rule itself. It's kind of, the rule says thou shalt not lie, and then the comment says, but yeah, it's not really a lie if you express an opinion about price or settlement. So it's kind of like the authors of the model rules had their fingers crossed when writing the text of the rule itself. And to a certain extent, this makes sense. How many of us in negotiation really believe everything the other side says when they're negotiating the price? I suggest that is a general accepted convention not to take that at face value. The place where this gets a little dicey, it's one thing to say, I think this property is worth X dollars, or this company is worth Y dollars a share, et cetera. The place where it begins to get dicey is where the statements statements bleed into things that are more matters of fact. For example, if in the course of a mediation, a mediator asks, "What is your bottom line authority?" That is not an opinion; it's actually a fact. And if your authority, if your authority to settle a case is $1 million, and you say, "Gee, my authority is $800,000. That's all I've got," that's pretty much a lie about a statement of material fact. It may never be uncovered, but I think that's where the line is drawn. If you're stating an opinion about price, that's one thing. If you're or an opinion or if you're stating your current willingness to settle for $800,000, as opposed to stating the fact that you have $800,000 of authority when you actually have more. So in the two questions that this hypothetical asked, I think one is okay. The other is, at least to my way of thinking, over the line. Although I will tell you, I've not seen a case on the matter of the question of stating one's authority I think that's more of a question of fact than opinion. So interesting, negotiation ethics are always interesting matters to discuss, but the takeaway here for me is make sure that you limit your stretching of the truth, if you're inclined to do so, to things of opinion, and not things that can be characterized as facts.
And here, Texas has adopted a substantially similar rule to the model rules, slightly different numbering, but encompasses the same kind of things that you're talking about. So let's go on to question number 4. Question number 4, the hazards of joint employee and company representation. Mark, I'm an in-house counsel that includes, my job duties include labor and employment for my company. The company and one of its VPs were named as defendants in a new lawsuit. I immediately walked down to the VP's office and asked him, what do you know about this? He asked whether I was asking in my capacity as counsel for the company, and so that our conversation would be privileged. And without thinking, I said, yes, of course it's privileged. Surprisingly, the VP then immediately confessed to me that he had made sexual advances on the claimant, but said, I can't tell anyone else in the company, especially the president, because it could get him fired, and that we should just settle the case quickly. What now? Do I have an issue?
Yeah, so you probably do have an issue, and the key here is going back to this conversation when you first came down to interview the VP or have a conversation with him. Your offhand comment that when he says, "Look, are you representing the company and me, so that our conversation be privileged?" When you agreed, when you said, "Yeah, of course," then you created a reasonable expectation in that vice president that you were not only representing the company, but you were representing him as well. And so you really have a joint representation going. And then when he confesses to you that he has actually done the wrongful deed, it sets up what is a classic Rule 1.7 concurrent conflict between him and the company. He does not want and is trying to instruct you not to tell this information to the company, but you have a duty to the company to tell them all the information you have, and so you're caught in a bind, and the what now is a tough one, because you have competing obligations to two different clients at that point, and you're going to have to withdraw from representing both. And in the context of an in-house position, that's a very difficult thing to do. And obviously you're going to have to get new counsel for both the company and the individual.
So when you say withdraw as counsel for both, obviously that's my job, right? And yeah. So I don't want to quit my job over this. Is it enough to say to the VP and to the president, I can't act as an attorney on this matter? Is that what you mean by withdraw, or does it have to be something more substantial? And then when the president turns to me and says, why, what can I say, or what should I say?
Yeah, the why is the easy part. You're going to have to say, I can't tell you why. I said easy. It's easy to say. It's not easy to do.
Right. Me and the VP are getting fired in this scenario.
Yeah. The withdrawal part is also difficult, and the cases diverge here a little bit. Some say it's sufficient that you just say, look, I can't represent, until this matter is concluded, I can't perform as a lawyer for either the company or the vice president. And so I'm basically just sidelined for a while. Others seem to suggest that actually quitting your job is the only way that you're or at least quitting your job as a lawyer. And so that's a difficult one, and that's one that requires some research into the particular jurisdiction involved, and that's definitely one. If this situation ever happens to you, God help you, please get outside counsel. Now,
Texas has adopted this model rule, a little bit different way it's written and organized, but what you're talking about. But how could I have avoided this? What should I have done when I walked
Yeah,
into
so
his office to investigate it.
everybody who potentially could find themselves in a joint company / employee representation should have a standard spiel that they utilize in having a conversation with any client representative, and that is to carefully identify who you're representing. When this lawyer went down to the VP's office, what he should have said is, I'm counsel for the company and representing the company, and in that capacity, as an employee of the company, things that you tell me will remain privileged. If you feel like you need individual counsel or independent counsel, then you should speak up and let's talk about that. So you should give employees in that context not exactly a Miranda warning, but at least a soft note that you are counsel for the company, and you're there definitely there to help them, but you're there to help them in the context of counsel for the company.
Does this need to be followed up with a writing or made in writing? Or do you think if you go in and say that I'm counsel for the company, whatever you say me will be privileged with regards to the company? Well, the problem is, right, you won't get the information. You won't get the truth from it. And I guess my question is it okay to just say that orally, or do you need to follow it up with a writing?
Yeah, that depends on how much you trust the people involved. It's not required that you have a writing to follow this up, and it's just a matter of trust at that point.
All right, question 5.
Before we move to question 5, there's a question in the Q&A. Do you have to tell the president that the company and the VP needs separate counsel, or can you tell the president?
Yeah, hey, that's a good question. I like that. Yes, that same awkward conversation where you're telling the president that you have to withdraw from representation of the company in that, at least in that matter, if not more, you have to indicate that you're also not going to be representing the employee involved, and that separate counsel should be obtained for both. But the trick is, as I discussed with Paul earlier, is you can't disclose the why of it at that point. So,
and so if the president asks you directly, did the VP tell you he committed a sexual advance? Your answer has to be, I can't tell you.
I can't tell you about the conversation I had with him or her.
Which might be an answer in and of itself.
Well, it certainly sends a message of sorts.
Right. Okay, let's hope no one gets in that spot, because that one is difficult.
Yes, it is.
Let's go on to question 5 about PR consultants as part of a litigation team. And you see this, increasingly in today's modern media world. Mark, my company has been sued in a very high-profile litigation that not only concerns a large potential liability, but could affect our perception and relationships in the marketplace. We are forming a task force of in-house and external counsel to work with management to defend the case, and we want to hire a PR consultant firm, crisis consultant firm, to help advise the team on how legal strategy may be perceived by the court and potential jurors, as well as how it will be perceived among our customers and our competitors, and how best to manage the company's messaging. By including a consultant of this type, do we risk waiving privilege on communication among task force members?
Yeah, and Paul, you're right. It's particularly in large cases. This has been in vogue for a while. And the privilege issue doesn't always become an issue. So I think folks have been lulled into maybe a false sense of security about including PR consultants and other consultants for that matter. It doesn't necessarily limit itself to PR consultants as part of the full litigation team. The short answer is there is a risk of privilege waiver. There is, and here's another brief plug. I authored a chapter on this very subject that's going to be coming out at the end of this year in a new ABA book on privilege. I highly recommend the book because it's going to cover all aspects of privilege in a very useful way, kind of short subjects. But this chapter in particular has a lot more detail than I'm going to give you today. There are two, the general rule is that if you include a third party who is neither the lawyer nor the client, that waives attorney-client privilege. Work product protection, ordinary work product protection is a little more resilient in this context. It's waived only if the presence of that third party makes it easier for an adversary to acquire the information. So it's less of an automatic waiver. But heading back to the attorney-client privilege, there are a couple of exceptions relating to the general rule about the inclusion of a third party being a waiver that relate to consultants. And there are two lines of cases. One line of cases follows a case called Counsel, and it builds on cases where the lawyer needed somebody to translate something. And it started originally with literal translators, where courts said, you know, if the client only speaks Spanish and the lawyer does not, and the lawyer needs a Spanish translator to communicate with the client, then the inclusion of that translator doesn't waive privilege. Well, over time, cases built on that, and Counsel actually held that the lawyer's use of an accounting consultant to translate, quote, translate accounting concepts in a conversation with the client was a reasonable extension of this and did not constitute a waiver of privilege. And there are a number of cases that follow this Counsel case. And by the way, these case sites will be in the written materials that you get after the program. So you'll get this. And then there's another line of cases that follow an Eighth Circuit case called Beater, where the third party, and this actually was an outsourced PR consultant. The third party was so integral to the client relationship that basically the consultant was the functional equivalent of the client. And in Beater, the consultant actually had decision-making. It was such an agent of the client that it had decision-making power for the client. And so in that circumstance, where the third party essentially assumes the role of the client, and no waiver occurs. So those are the two lines of cases you have to work with. Unfortunately, and these cases have been applied both positively and also have been rejected in the case of PR consultants. And this slide that's currently up lists some of the cases, positive and negative. For example, in the In re grand jury case, the court held that privilege was not waived, where the lawyers literally used the PR firm to design as an integral element of their legal strategy a PR strategy to influence prosecutors not to charge in a grand jury process. Similarly, in the Viacom, the Copper Market case, again, the PR firm had enough authority to act for the client, it was considered the functional equivalent. But the recent trend has kind of been the other way on both of these. Anderson versus SeaWorld, it dealt with a movie that was made about SeaWorld that was very unfavorable, and litigation ensued over it. And SeaWorld hired a crisis management firm to help the law firm figure out, in cooperation with the client, how their legal strategy would sell to in the marketplace, as well as in court, basically to help them drive their legal strategy in an appropriate direction. And so it wasn't all that much different than some of the cases going the other way. But in that case, California case, I think, they said, no, that did constitute a waiver of privilege. Similarly, on the functional equivalent side, LG Electronics just stands for the basic proposition that if the PR firm really is not a sufficient agent of the client, it doesn't have the decision-making authority, it's not going to fit within that line of cases. So two things about this. One is that the safest way to do this is simply not to include the PR consultant in every privileged conversation, because then you're putting yourself more at risk. If you can use the PR consultant, if the lawyer can just have the PR consultant as a retained expert and communicate with them to ask them questions directly without involving them in the flow of attorney-client communications, then you're probably in a lot more solid ground. And that is because
Mark,
the second point.
Here's my question.
Let me make one more point, Paul. The second point I want to make is that's largely true because work product protection is more resilient. And so if you're able to put the consultant under the umbrella of work product, even if attorney-client privilege doesn't apply, then you've got a better shot at keeping those communications, at least the written communications, confidential.
Have the courts addressed, or do you have an opinion as to whether or not, if the law firm directly engages the PR company as a consulting expert, that changes any of this analysis or strengthens the likelihood that they'll be considered part of the litigation team or protected?
Yeah, that's kind of what I was talking about at the end there. But the trick is not to get carried away with it. A consulting expert works fine if the law firm simply consults with the expert about the things they need to understand about PR. But the difficulty arises when, such as in the SeaWorld case, if they involve the consultant in the regular stream of attorney-client communications with the client, you're not going to be able to protect those communications, the privilege on those communications in that circumstance, because then the PR consultant has gone beyond being a consulting expert. They've been in the middle of the at least in the jurisdictions where, and then this is again a topic where you need to know where am I? Where is this court? Is it in a venue where there's a favorable case, or a venue where the authority is a little more challenging? And frankly, the recent cases have tended to be more limiting in extending privilege protection here.
All right, let's go on to question 6. Involving instructing corporate employees in litigation. Mark, I'm counsel for a corporate client in litigation. May I instruct or ask the company's employees not to speak to opposing counsel about the case? May I instruct or ask the company's former employees not to speak to opposing counsel about the case?
Yeah, so generally, yes and no. This question primarily implicates Model Rule 3.4, particularly 3.4F, but we also want to take a look at Rule 4.2. 3.4 has to do with when the lawyer can ask somebody not to give information, and Rule 4.2 primarily defines who the opposing lawyer can communicate with, and therefore kind of covers the other side of these communications. So Model Rule 3.4F says a lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to the person. So the other than a client language makes it clear that you can request a client to not to voluntarily give information to the opposing counsel or any other person for that matter. So if the person you're talking about is a current employee within the structure of your client, then you're on solid ground asking them not to talk to the opposing party. There's another exception here which I didn't talk about, and that is you can always ask a relative a relative of a client not to talk to the opposing party as well. Provided in the proviso here, there's number 2 on the screen, the lawyer reasonably believes the interest of that particular person won't be adversely affected for not giving that information. And that's I've really never seen a case talking about that particular provision. So you're on solid ground with the current employees. The difficulty arises with former employees. Former employees are not within Rule 3.4F. Rule 4.2, though, does bar the opposing lawyer, at least without consent, from speaking with persons the lawyer knows to be represented in the matter. And that includes any constituent of the organization who supervises, directs, or regularly consults with the organization's lawyer about the matter, whose act or omission in connection with the matter can be imputed to the organization for purposes of liability. Again, however, Rule 4.2 does not on its face, at least, talk about former employees. And the general, I'd say the general rule, maybe the overwhelmingly majority rule, is that corporate counsel or counsel representing a company cannot instruct former employees not to speak to opposing counsel or others and hold back information. And that is with one exception. It is always appropriate to ask a former employee, as well as a current employee, not to reveal information that is otherwise protected, such as privileged information. Their discussions with corporate counsel during the time of their employment, and other things that would be covered by appropriate agreements, non-disclosure agreements, or other things that would be limited by law, simply reminding them of their legal obligation not to disclose information in the absence of a compulsion to do so. So that you're on fairly solid ground there, but in terms of just simply urging a former employee not to talk, you really can't do it, at least in most jurisdictions. There is one, you do have one tool in your box. It is sometimes an expensive tool, and it requires some cooperation. And that is if a former employee is sufficiently important to the matter and they're amenable to it, you can always engage separate counsel for them as an individual to advise them and obtain independent legal advice. Obviously, if they have their own counsel, then the opposing lawyer can't speak to them without involving that opposing counsel. Now, that doesn't mean that they're going to act in accordance with the company's interests rather than their own interests, but it does provide some protection and may give you an ability to communicate with their personal attorney in order to explain why it might be to their advantage or that person's advantage not to make disclosures that would be harmful. So that's a tool. It's a less than full value, and it's a little bit expensive, but it does give you a little bit of protection.
What if this were included in a separation agreement? What if the company had employees that were leaving sign a separation agreement that included a non-cooperation clause that they would not voluntarily cooperate with the opposing side or the opposing attorneys as part of their separation agreement, for which they're presumably getting some compensation? Does that change your analysis of former employees?
Yeah, that's an interesting strategy, Paul, and one that I have not seen played out in the case law, frankly. So I don't know that this has been tested, at least in a case that I'm aware of. Again, in the context of the rule, though, it would be appropriate to remind a former employee of their obligation, of their contractual obligation. That doesn't mean you can instruct them as a lawyer just out of the blue not to talk, but you can say you do understand that you have an agreement, a non-disclosure agreement with the company that you signed upon your departure.
And we got a question about that. Did you see that?
Yeah.
The first question was, would an NDA serve the same purpose?
Yeah, I think it serves the same purpose to an extent. It at least gives you something to talk about that gets you past the limitation of the ethics rules. It may or may not be ultimately enforceable. It probably in many circumstances it's not enforceable against a subpoena, but it does give you something to talk about it.
And then the other question we got was, can the company pay for the individual lawyer of the former employee?
Absolutely. There's no prohibition against that. I also see, looking back at the Q&A, we did get a question about the PR question, and I apologize for not seeing that at the time. We may have actually covered it accidentally. how does a PR firm differ from a consulting expert advising litigation? So you basically did ask that question, and the answer is it doesn't. The trouble with involving a PR firm extends not when you're using them as a consulting expert. It extends when you're involving them in the trail of communications with the client and putting them in the window of an attorney-client, otherwise attorney-client privilege communication that then loses its privilege because of their involvement. So, okay, I think we're up to date now.
Yeah. And I also think that Texas model rules for this question 6, the corporate employees, they've adopted largely the model rules in Texas. Once again, different numbers, but pretty similar. All right,
Okay.
want to move on to question 7?
All right, here we go.
All right, oversharing. I met my life partner in law school, and I'm now happily married. We both practice law. How you could be happily married with 2 lawyers in the same house, I don't know. And we enjoy sharing each other's experiences and challenges of our professional lives. Today, I begin to work on a particular type of matter. First time I've done it, but I know it's one my spouse has handled a number of times. So I'd like to explain the situation to them confidentially, and we've agreed we're not going to share this with anyone else, and ask for their input on some aspects of it. Are there issues with this? What if we only use hypotheticals without identifying parties or the specific matter?
Yeah, so this may sound like something that would never come to light. However, I'm here to tell you that it did at least one occasion come to light. It's something I've actually dealt with in my professional career. So sometimes these things do create issues. So let's start at the beginning. First off, if this is you, congratulations on your great relationship and your commitment to communication to keep it that way. But there are, however, professional limitations on sharing with your life partner. There is no spousal exception to Model Rule 1.6, for example. It's protection of confidential information, which relates to, quote, all information relating to the representation of a client, close quote, not just privileged information. In addition, as we talked about with regard to the PR consultants, any disclosure of privileged information of a client to your spouse as a person not within the privilege umbrella for that client would constitute a waiver of privilege, at least to the extent it's uncovered. And if discovered, these facts could create some serious adverse consequences for you and your clients. And sometimes this can happen, maybe not so much in an oral conversation, but if you've traded emails during the workday, for example, with your spouse, and even if it isn't discovered, this places you in violation of the rules that you've committed to follow. So I'm urging you to follow them. You also asked about, or the question asked about the use of hypotheticals. So the rules do not, and Model 1.6 doesn't change this. The rules do not prohibit discussion about legal issues or processes in the abstract, disconnected from information relating to an actual client representation. So hypotheticals are an option if you wanted to pick your pick your spouse's brain about some expertise that he or she has. As long as you're careful about proceeding in this manner so that the context of the discussion doesn't expressly or implicitly reveal the identity or information of a client, you're probably okay. And so if that's something you really do want to try to get some information from your spouse about, rather than just telling war stories, then a hypothetical may be acceptable so long as you're careful about it.
And the real world implication is don't send emails with the documents to your spouse, because that might have happened and that might have gotten people in trouble on this very exact question, even though it sounds like the kind of thing, like Mark says, that would never come to light.
It might have cost somebody their job.
Really might have. All right. Question 8. Relationships. Mark, we live in a complicated world. I've been a lawyer for a long time. Most of my friends and acquaintances are lawyers who do more or less the same things, some in-house, some at law firms. And I'm dating another lawyer who also has a similar practice in another company. In representing my client, I often find myself opposite a friend or an acquaintance, and now I have a transaction opposite the lawyer I have a dating relationship with. I'm struggling whether any of this needs to be disclosed to my client, requires a waiver, or is just flat out of bounds. I'd also like to know if other lawyers have an obligation to consider their relationships in dealing with me or our company.
Yeah, we do live in an increasingly complex world, and in the context of this question, somebody needs to create an app that your relationship status reflects whether you can whether you're disqualified or not in a particular matter. But there is guidance here. Comment 11 to Model Rule 1.7 addresses conflicts when lawyers are closely related by blood or marriage, represent different clients in the same or substantially related matters. And then there's an ABA ethics opinion, formal opinion 494 from a couple of years ago in 2020, provides some guidance in particular contexts. And so it really has three categories of relationships here. Going back, comment 11 itself does define certain relationships by blood or marriage. And so those are pretty easy to track, and I'm not going to cover those. But three categories of informal relationships. Starting with the easy one, if someone is a mere acquaintance, somebody you know, then you have no problem at all being adverse to them, or representing one client adverse to a client of theirs, and no disclosures are required. And then there are two other categories, and we'll start at the top of the slide: an intimate relationship. And for purposes of the ABA opinion, it defines an intimate relationship as cohabiting, engaged to, or an exclusive intimate relationship. So this is cutting things pretty fine. If you had an intimate relationship, but it was non-exclusive, then it's not an intimate relationship under this rule, under this opinion. I don't know. It is what it says it is, but it's a very fine line. In that case, if you fall within that bucket of having an intimate relationship, then the relationship must be disclosed to clients and waivers obtained, so long as the lawyers involved reasonably believe that they can competently and diligently continue with the representation. And that means being able to vigorously advocate against the lawyer on the other side. Would you, if it warranted it and your client wanted it you to, for example, would you seek sanctions against that lawyer if you were in an intimate relationship with him? I submit that may be a difficult one to make that determination, but there it is. And then the middle category is really everything else, a friendship of various degrees. So here the ABA's guidance is there are different friendships. Some friendships are more like intimate relationships, where you really have a very close relationship. In that circumstance, you probably should disclose the friendship and get waivers. Other friendships are just more casual friendships where you wouldn't have any problem being adverse to that person, and they're more like mere acquaintances, and they aren't an issue.
And
So
by the
Paul,
way, in Texas,
Texas
did not adopt any of these rules, and there's really no mention of the Texas rules on blood relations or marriage. There is one Texas ethics opinion, legal ethics opinion 528, addressing the issue of whether an attorney can represent clients in a case against a company when that attorney's spouse works for the company. And in that ethics opinion, the court concluded that they could, in part because the attorney wasn't going to be working directly on the case and his wife was a relatively low-level employee. But so Texas has even less specific guidance than the model rules or many other states on this. Okay.
And Paul, I see we're at the end of our window here, so we only got through 8 of these, but I hope they were relevant to everyone. Walter, if you're on, if you could skip to the last slide. There you go. Because I needed a PowerPoint slide to remember to say thank you, as it says on this slide. But what I really wanted to reference this slide for, again, if you found these questions and answers useful and would like to see more of them, and we have both the old ones posted on our website, and we'll continue to to process the new ones, I have 75 problems like this that I will be cycling through over the next couple of years. If you're interested, there's my email address, mark.hendricks@stinson.com. Just drop me an email, say, please add me to Dear Ethics Lawyer, and we will do that. And I'm so grateful that, as is Paul, that you have participated with us today. And so, Susan, thank you, and we'll turn it back over to you.
Thanks.